Ena mana, ena reo, ena waka ona hau e whā. Tēnā koutou, tēnā koutou, tēnā koutou katoa. No ina rangi me ko te rangi o ku tūpuna, no te whanganui a Tara a hau, ko tangata treaty, ko Gina Sweetman a hau. No reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Good morning, everyone. My name is Gina Sweetman, and on behalf of the Hearings panel, welcome to the hearing of Plan Change 79 Deferred Zonings. For those who don't know me, I'm an Independent Hearings Commissioner based in Te Whanganui-a-Tara, Wellington. I'm a planner by qualification with around 32 years experience, and I've been practicing planning and been practicing as Commissioner for the last 13 years. I work nationwide for regional councils and territorial authorities, covering everything from regional policy statements to resource consents. Wearing a different hat, I'm also contracted part-time at the Ministry for the Environment, working as a Chief Advisor on resource management reforms. We're not going to talk about that today. Certainly a changing ballgame at the moment, and our focus today will be on Tasman District Council matters. Sitting with me on this hearing are Kit Melling and Christine McKenzie, who I will let them introduce themselves. Kit.
Good morning, everyone. Kit Melling, Richmond Ward Councillor. This is my 4th term on council, and I first qualified as a Hearings Commissioner in 2011. And then had to qualify again when I went back on council in 2016. I've sat on a number of plan changes over the past years and have been involved in council business and the Richmond Ward in particular since 2010.
Good morning. I'm Christine McKenzie. I'm a 2nd term elected member for the Tasman District Council, representing the Moutere Waimea Ward. I first qualified as a Hearing Commissioner in 2020 and have done maybe 3 or 4 plan changes for the Tasman District Council. Professionally, I'm a chartered accountant with a career in the public service. Thank you.
Now that we've introduced ourselves, I'll get everyone in the room to introduce themselves. So, Anna.
I'm Anna McKenzie. I'm just assisting today.
Yeah, good morning. I'm Barry Johnson, Environmental Policy Manager at TDC here. I'm assisting as well.
Morena, I'm Mary Honey. I'm a planning officer for this plan change. I'm a senior policy planner at Tasman District Council and have been for about 20 years.
Morena, Jeremy Butler, Team Leader for Urban and Rural Policy. I'm the reporting officer particularly for the Lower Queen Street component of the plan change, but assisting with the entire scope of the plan change.
Yeah, kia ora, Bill Rice, Transport Advisor with Tasman District Council.
Morning, Michael Goldingham, Team Lead, Infrastructure Planning.
Kia ora koutou katoa, ko Dr. Alistair Clementaho, Team Leader, Natural Hazards and Geomorphology.
Welcome, everyone. Just a few other things to run through. Now, we did set out our proceedings in our first minutes, so I'm not going to go over those in detail, but I will summarise the important parts. So we have read through all the information that has been provided to us to date, so that can all be taken as read. The focus of the hearing is really for us to get a better understanding of the key issues in contention and hear the concerns from the parties involved. So we will hear from the council officers first, and then we will move through to submitters. Now, Ms. Ford, we have you going before morning tea and then after morning tea, but we have heard that the fields aren't going to be appearing this morning, so you will be first up after the council officers. Know that I'm expecting for an hour. I hope that everything will be able to be delivered. Thank you. We will be adjourning at lunchtime and undertaking a few site visits around before reconvening and hearing from the balance of submitters. We'll give then the officers an opportunity to respond to some of the matters raised during the hearing. But certainly at this point, we can indicate that it is highly likely we will be asking the planners to conference and produce joint witness statements before we ask for the final council reply. So just an indication there. We will endeavour to make this hearing as informal as possible, but just some key ground rules, and those are to treat all parties with respect. There is no cross-examination and no interrupting other parties either. And all questions that you might have need to come at the time that you are presenting. I will just head to Mr. Johnson to do some housekeeping for us, please.
Sure. Just a couple of things. When you come up to speak, please use the mics because we have some people on Zoom as well. If you need the toilets, out the door and to your left. If there's an earthquake under the bench, drop, cover and hold. And if the fire alarm goes, then out here and out through the front door and out into the car park around the back. I think that covers everything.
Thank you. Now, before we start, are there any matters any parties want to raise? Commissioner Melling is very familiar with the area, so he's pretty confident that we can do that ourselves. Thank you. Okay, we now are scheduled to hear from the council officers. Obviously, we have received your Section 42A report, and thank you very much for providing your rebuttal evidence last week, which we have also reviewed. Really over to you. We've got you allocated for half an hour, but it's likely we'll have a few questions as well.
Yes. Okay, thank you. We've got a short statement which we'll read to. It's a brief overview with some updates and updates on approach. And please ask questions if you'd like us to address something that we haven't. So obviously the overall purpose of PC 79 is to introduce a modified deferred zone framework that is legally robust, and also to release for development existing deferred land, that is land that has previously been rezoned to a deferred zone through a Schedule 1 plan change process. we release this land provided the services are available and on full assessment, the destination or end-use zoning is still appropriate. If it's not, the location is being recommended to be downzoned or appropriately rezoned. So back to the modified deferred zone framework. This in a nutshell, operates in tandem with two other relevant zone chapters and a trigger rule. In effect, the zone chapters, one of which is generally the existing or a rural zone, and the other the destination or urban zone. So the zone chapters and the trigger rule, which is which is linked to the provision of infrastructure, which is clearly described. So the zone chapters and the trigger rules operate and provide this new deferred zone framework. And once the trigger rule is met or satisfied, the land in question can rely on the existing TRMP provisions that provide for urban activities. There is no zone change at this point. For existing deferred land to remain deferred, and for additional land to be deferred after PC 79 is operative, funding for the infrastructure should be included in the Council's LTP within the next 1 to 10 years. And infrastructure upgrades required to service the area identified both in the TRMP and the LTP clearly. So as we all know, the scope of this plan change has excluded deferred zone locations in Mapua and Motueka. The reason really for this is that existing planning processes are occurring for these towns that will address the issue of zoning. Just a couple of words about context. The operative TRMP deferred zoning process that may be legally uncertain is a method that has really been valued by council and the local development community. It really assists to manage the gap between the demand for and the supply of surfaced urban land needed for growth. It enables council to plan and prioritize funding. It enables developers to plan to provide infrastructure in collaboration with council, thus reducing holding costs and increasing certainty. It also enables stakeholders to obtain alternative sources of funding if they want. A recent example of this has been the Motueka West Compact Density Plan change, which got funding contributions from the Infrastructure Acceleration Fund. Hence the effort to provide a proposal for a deferred framework that is legally robust. From the time that the legal robustness was questioned, which was about December 22, council stopped uplifting deferred zones by council resolution. Since that date, infrastructure has been built. Several locations with the deferred zoning are now serviced and ready for development. These locations are really needed for growth. Hence the opportunity to upzone, rezone at the same time that we introduce a modified deferred zone framework. So updates not included in the papers. At the last minute, the Fields, the owners of much of Richmond South, location 14, have sent a statement that they support the rezoning of RS14 to residential, but they still do not support the staff recommendation to retain the deletion of that portion of the indicative road that connects to Hill Street. So the landowners in Richmond South don't support the deletion of that road, that it's a portion of a road. There's also an update on the Mapua Master Plan decision-making process. Following feedback, following public feedback on the master plan, Council staff, and that is Anna, who's sitting here, has confirmed that the deferred portion of 166 Mapua Drive is recommended to be rezoned as medium density residential. The recommendation was accepted by the committee and is expected to be formally adopted by Council on the 31st of July. It is also expected to be included in Plan Change 81 Urban. That is scheduled to be notified in the third quarter of this year. So following the filing of expert and legal evidence, we consider that the remaining areas of difference are the following. The workability of the provisions comprising the deferred zone framework as recommended by the Section 42A report. The deferred zoning framework provisions that apply to deferred zone locations, the deferred zone locations that are not included in the proposed Schedule 1714A, that's Motueka and Mapua, also as recommended in the Section 42A report. The coastal inundation provisions relating to Lower Queen Street light industrial land and limitations on subdivision as proposed in the Section 42A report. The deletion of a portion of an indicative road in Richmond South leading onto Hill Street. The rezoning of the deferred portion of 166 Mapua Drive owned by Mount Hope Holdings. The rezoning of Brightwater site location BW16 at 72 Waimea West Road to conservation without provisions that address direct access to Snowden's Bush from Waimea West Road. So in this regard, we've got a couple of update comments. Staff really recommend that the proposed deferred framework provisions as set out in Chapter 17 are sufficiently certain. Council staff reply to evidence refers to this, and my reading of the legal evidence of Appleby 88 and Mount Hope Holdings is that they hold a similar view. The legal submissions of Mr. and Mrs. Talley suggest that the only way to resolve the issues that they identify is to delete circumstance 2 from proposed Rule 1714 2.2, meaning that in order for infrastructure to be delivered, it would have to be actually constructed. This approach seems to lack any practicality. Infrastructure often needs to be planned and built in conjunction with landowners, developers, and the end use of the land. But the end use of the land depends on the resource consent process, which cannot be commenced until final urban plan provisions are in place. Not allowing final urban plan provisions to be in place until all infrastructure is physically built would just create a chicken and egg scenario, a costly backup and a costly lag. It's for this reason that the 3-year window in 1714 2.2 is critically important. It allows for funding for the necessary infrastructure to be locked in to the first 3 years of the LTP. This in turn triggers the availability of the final urban plan provisions so that the landowner can rely on them and apply for resource consent with the correct status, not as non-complying or full discretionary status. It is this planning phase and resource consent approval which will actually shape the final infrastructure that is to be built. In summary, land development takes years of planning and collaboration between landowners, developers, and the council. Having some flexibility and efficiency is absolutely critical for a high-growth jurisdiction such as Tasman. The second point, the deferred zone, relates to the deferred zone framework provisions that apply to the deferred zone locations that are not included in the proposed Schedule 1714A. And we know these are the locations in Motueka and Mapua. So these have taken up a lot of time and attention. Following submissions on this issue, Council has really confirmed in the Section 42A report that PC 79 does not intend to extinguish all RMA and TRMP development pathways for these locations that are shown on the operative planning maps and still are on the operative planning maps. The resource consent and private plan change pathways remain available to these deferred locations. So staff acknowledge that the plan changes as notified was not always clear with this message. And to this end, we've recommended amendment to the proposed schedule of plan amendments to clarify this. The operative provisions, with some clarification amendments, support further development of all deferred land, including land that is not listed in Schedule 1714A. And in the Section 42A report, there's a list of these provisions. The new provisions, which refer to the new trigger method, apply only to deferred land listed in Schedule 1714A. And again, the hearing report lists these provisions. The new provisions use the word delivered. The operative provisions have been amended to not use the word deliver, because deliver is particularly defined in relation to the trigger. Just an update in regard to Schedule 1714A hearing version. Regarding the legal evidence of Mount Hope Holdings and Appleby 88, para 82, page 20, staff agree in principle to the inclusion of Chapter 6 in column C of 1714A. And we agree that the bulk water and stormwater requirements added in purple print to the Richmond West 5, that's Machine Road, column D, are not appropriate, and that we should revert to what was in the proposed changes notified. Okay, that's updates that I'm going to present, and Jeremy, I think, is going to present the rest.
So just to, thank you, just to follow on from Mary's statement there regarding the coastal inundation provisions relating to Lower Queen Street. The approach taken to Lower Queen Street light industrial land reflects a balance between enabling some industrial development that is sought by landowners who have invested in the land, and we've recognised that, but also responding responsibly to the increasing risks associated with coastal hazards. This land is serviced and strategically located to support economic growth, but it's also in a location that's vulnerable to coastal inundation as a result of projected relative sea level rise and increasing intensity of storm events. Proposed provisions maintain the zoning uplift to a light industrial zone, but also include targeted limitations on land use activities and a prohibition on new subdivision, which was recommended in response to submissions. These limitations are not designed to prevent development altogether, but to ensure that new development proceeds in a way that is adaptive, resilient, and capable of responding to changing environmental conditions. And that's all from the officers for now. Happy to answer any questions.
I've got a question of the staff. First of all, is the uncertainty in the long-term plan of 3 years, the first 3 years, because councils change those long-term plans depending on funding constraints. So what do you say about that?
I think it is acknowledged that there is some uncertainty. Funding can change, but within that 3 years, the advice that we've had is that there is a quite a high level of certainty. There is the process will require that zoning decisions are reflected in the infrastructure that's provided for in the long-term plan over that 10 years. And that's made clear to councillors when developing the LTP. The first 3 years is the most certain that infrastructure is locked in for that period. There can, of course, be changes, but the implications of that would need to be understood. If the infrastructure is not delivered or not provided for, then the deferral cannot be. Well, the trigger of conditions is not met. Once the trigger is changed, through the process we've identified, then it would fall to the resource consent condition. So the resource consent process. So there is still the backstop of the resource consent process, which would need to deal with that. So even though a landowner may have the benefit of the new provisions, being let's say for argument's purposes the residential provisions, they would still need to go through that resource consent, and if the infrastructure is not available, they wouldn't be able to progress that resource consent, or they wouldn't be able to build that development until that infrastructure is provided, is actually built. So, and that's how it's worked effectively, as we say, with a very similar mechanism previously. That there's been an understanding that that resource consent and implementation of that resource consent is depending on actually having that infrastructure available.
So your backstop is actually the resource consent, because there's an example where infrastructure has been deferred this year in an annual plan. So it's a change from the long-term plan.
Yes, that's understood. And we recognise that that there can be changes, but generally the biggest infrastructure. Well, hang on, I'll rephrase that. When making decisions on the annual plan and making changes to that first 3 years, in my experience, there is a recognition of what the implications of that would be. So if infrastructure were to be deferred or delayed or taken out, it would be recognised that that there are implications of that. And in my experience, in discussion with infrastructure planning officers, that would be made clear that there's some infrastructure that could be removed without consequences, but there's other infrastructure that if it was taken out, there'd be significant consequences for already zoned land. So when I say that, I mean that the trigger has been passed because it's within that 3 years, and therefore, if it was to be removed through the annual plan process, that would have some quite significant impacts, and so therefore it would be strongly advised, that infrastructure is to remain in the annual plan process. So I understand, to remain in the LTP and not change through the annual plan process. So I understand that may be a concern at the time, and those changes may have happened, but it would have to be seen in the context of this process, that zoning is effectively in place, or those new provisions are in place, and therefore that infrastructure is necessary to provide for this effectively this available zone, these available rules. If that makes sense. I don't know. It's possible. My colleague Mr. Goldingham might have some further comment on that. No, don't have to. But happy. Okay.
Thank you, Mary and Jeremy. Just in terms of the satisfying ourselves as to the legal robustness of this approach with the deferred zoning. I mean, we found ourselves in a situation where it was suggested that maybe we weren't legally robust in terms of how we were progressing. Now we've got a change of approach, which we understand that some other councils are using. But what gives staff the assurance that you're satisfied as to the legal robustness of this approach?
we're satisfied because the modified deferred zone framework does not actually change the zone of the affected land. It merely applies different provisions. The operative deferred zone framework actually changed the zone of the land, and you cannot change the zone of land. You cannot change zone without a Schedule 1 plan change. Here, instead, on certain conditions being met, different plan provisions apply. That's the difference, in essence, between the operative and the proposed modified framework.
If I just add to that, so what it boils down to then is the legality and the certainty of that trigger process, of that delivery. And so we also recognise that the plan is not changing before and after that trigger is reached, and we are satisfied that the delivery is sufficiently well defined and sufficiently objective that with the criteria that it's funded within the 3 years, or it's actually constructed, that can be a sufficiently objective decision, a trigger point that doesn't require judgment. So that being the case, it either has been delivered or it hasn't been delivered, and that triggers the change in rules, as Mary said. So between those two components, we're satisfied that it's a process that can work practically, but is also sufficiently certain.
And so what professional advice have you relied on to satisfy yourselves as to the robustness of this approach?
So Council received advice from several quarters, most of which is included in the Section 32 report, so it's available for all to see. We note, I note with caution, and perhaps Sally Gipp can confirm, that the legal evidence for 88 Appleby Highway and Mount Hope Holdings has actually set out legal evidence that confirms this, which we acknowledge we are happy to receive.
Yes, and then we have legal submissions from tallies who say that it's not legally robust. So has the council received its own legal advice on the robustness of your proposed provisions?
Yeah.
Yes, we have.
And is that something you can make available to the panel?
I'll have to check with our in-house counsel regarding that first and get back to you.
Thank you, Mr. Johnson. Now, in your reply submissions, you make reference that you've had a look at some other district plans, or some other council plans, would be district plans, and that 4 of the 12 councils use a framework similar to the TRMP's framework. So we'd be quite interested in having a look at that information in terms of how other councils are approaching deferred zonings, particularly any more recent district plans.
Yes, of course. There's a summary report. It's an in-house report, so it's not all beautifully set out, but there is a report, and we can make that available.
You can take that as a matter that we will be asking you to provide through your reply report. Now, just changing tack a little bit and dealing with the Lower Queen Street matter and the light industrial. Prohibited activity status is obviously the strongest, and you can't do anything in terms of prohibited, in terms of applying for a consent. Is the use of prohibited activity status consistent with other approaches that you've used in the TRMP?
Yes, it is. The prohibited has been used for over rural one land to not allow development or subdivision near Mapua. So that was Plan Change 22, brought in a coastal hazard area which prohibited subdivision. I acknowledge that light industrial uses are different to residential, but nonetheless, in this location, it's certainly seen as an appropriate approach, given the level of hazard into the future. Also, I should also say there are a number of other prohibited activities that are used in the TRMP, but specifically the Plan Change 22 instance around Mapua and Ruby Bay is the most relevant.
Did you consider a non-complying activity route?
Yes, absolutely consider that. And it was considered, it was discussed, but given the circumstances, it was hard to see how, given the guidance, really, it was the guidance, the NZCPS, the NAP and other high level guidance and advice from MFE and advice from in-house staff relating to hazards, that prohibited was the best approach. It's not considered a appropriate way to allow more landowners to come into that space. Really the starting point for the council's position was that actually this area of land is an area we should retreat from. It's not an area we should allow development. It's hopefully not going too far to start getting into Mr. Taylor's evidence, but I feel that, and I think I set this out in the reply, was that the starting point there was it should be developed and that there could be controls put on that are appropriate. The starting point from the officers was, or from myself, was that no development's appropriate, but recognising that it can be used for a period of time, and recognising that some owners have invested in that land and have been counting on that land for their livelihood and to be able to relocate their business, their industry there, an allowance for a period of time should be provided. But taking that next step forward of actually allowing those landowners to become essentially developers and making that land available to new other people to invite into the area, that was seen as inappropriate. Hence the prohibited status.
In reading your reply to the evidence over the weekend, I noticed that you were quoting the case law in relation to, I think it was king salmon and a void in relation to Lower Queen Street. And from my recollection, we've had overtopping of Lower Queen Street in the lower part. I think it was Cyclone Gita. So could you just explain, in your evidence, you're talking about allowing development for, I think it was the near to medium term was the words you used, but not the long term.
Yes, it was Cyclone Fahey. It was, but absolutely the advice I've had from Mr. Clements particularly is that the way we have to think about the hazard in that location is, and I think I put this in the reply evidence, is that it's not a static, gradual increasing of hazard. It's punctuated by these events such as Fahey. So, and we can't predict these. We don't know when they're going to happen. We don't have much time to prepare when they do. And as the sea level rises, all of a sudden, an event like that will come through and it will overtop the road. It'll inundate whatever's behind that road, and it'll be damaged. And gradually, over time, over the decades, as the decades go by with sea level rise, those events will happen more and more frequently. and the smaller storms. So maybe I don't want to get into specifics here. Happy if we do want to get into specifics, Mr. Clement's here to answer questions. But smaller storms will then have the same impact as Waihi, and so more frequent return interval storms will have those impacts. So they will continue to increase, ramp up, and become more impactful on that land. And so at some point, if we are to enable some industrial use of that land, we need to have a trigger level or a trigger point at which resource consents need to be reconsidered, activities need to be reconsidered. And so my approach is that anything that's built on that land should have the ability to be relocated or deconstructed. And it should be, the purpose of the land should be to provide for the uses of the landowners who own it at the moment, or they may sell, I guess, but without that subdivision, as I said before. But I'm sure Mr. Clement's will be able to answer further questions if just around Cyclone Waihi, if that's useful.
It's not about Waihi, but it's about the land down there. When you look at the zoning, it goes from Swamp Road up to McShane's Road. Some of that land is inland from the MDF plant from Nelson Pine, which protects that land in some ways because it's a considerable distance from the sea, and Nelson Pine is also raised. So not being a hazard expert, but it seems to me that there is a difference between land near McShane's Road to land near a swamp road. But in addition to that, some of that land nearer to Swamp Road has been raised over a period of time as well. So Mr. Clement might be able to comment on, Dr. Clement might be able to comment on that for me.
I guess I'm just wondering if there's a specific question, or if you're just like
is there a difference between one end to the other?
From the lower to the higher?
Yeah.
So yes, there is a difference in exposure to coastal hazards, depending on where you are in that Schedule 17.4A area. So yes, as you move further away from the coast, generally the exposure is less, and that is because the land elevations are higher. I can go into more detail, but that's the crux of it.
And if I could just add to that, sorry. If I could just add to that, though, the analysis that was done, that was guided by the National Guidance and National Direction and Policy 24 under the NZCPS, identifies that there is a methodology for working out where is the point at which that hazard, and that was the 5.1 metre contour above mean sea level. And so it becomes arbitrary. Deviating from that line, it becomes an arbitrary guesswork of how far you go. Just as you've said, it's a very, very gradual loss of altitude, I guess. So that is the line that we consider as appropriate based on national direction.
I'm just wondering, can you point me to the actual piece of evidence that shows that allowing land such as this to be subdivided will have the unintended consequences of exacerbating the impacts of inundation?
Might have to think about that for a minute. Yeah, if it's okay, I might get back to you on that. I just need to think about when you say the evidence that it might exacerbate. Do you mean other examples, or from my experience and expertise in resource consent planning background and policy background?
I'm thinking maybe other examples.
Sure.
Because the premise is that allowing subdivision will create some unintended consequences, negative impacts, should there be, ongoing inundation. So we can have that view that we assume that that's what will happen, but I'm just wondering if there is some factual examples.
Sure. Yes, I'm more than happy to have a think about that and provide that. From a practical point of view, and I guess my experience as a resource consent planner, about 15 years as well, I've seen those scenarios. And I guess if we take an example that may come up, being the artillery place. So if a subdivision such as that were to be developed, each landowner would then have their, an industrial site, maybe 2,000 square meters. At the moment, we have a situation where one of these larger sites could be developed. We've heard from Dr. Clements, and you've said observed yourself that there is a range of circumstances. Over the decades, it may well be possible for buildings, let's say a storage building or a trucking depot, such as what Mr. Drummond's that's there at the moment, to be able to actually relocate it back. Might get another 20 or 30 years out of it by relocating that back another 50 metres or 100 metres away within the same property, which is available to them. And then after that time, maybe it has to be relocated. If you've created a subdivision and you essentially have static, you now have, I'm just throwing numbers out there, but 10 new sites that are created of 2,000 square metres, there is no opportunity for those land uses to be then relocated further away. Equally, additionally, you've got tar seal road formations, you've got underground pipe work, stormwater pipes, electricity, fibre optics, wastewater, water supply, all of that underground piping, which I imagine would fall to the local council to have to remove or clean up. So all of that infrastructure that goes with a subdivision, as well as the sites themselves, frankly, I just don't see why on a retreating coastline we would allow that, when all the national direction says to avoid, do not allow. It's very, very clear, do not allow additional development in these and hazard-prone locations.
Okay, no further questions for the council officers, and we've gone slightly over time, but that was very helpful. Thank you. As I said before, we will have some further questions for you later. We'll now move through to submitters, and the first submitters that we have up are those represented by Ms. Ford. So Ms. Ford, did you want to come forward, please? Now we have you. If anyone does want to come forward, if you have laptops and you want to sit around, please do so.
I've printed out copies. I know that these only.
Now, while those being circulated, the council officers, Mr. Butler and Ms. Honey, can you please provide your speaking notes that you were talking to the panel as well? Thank you.
I'm joined here with James Patterson on my right, Julian Rain on my left, Mr. Stuart Flowerday and Mr. Brett McLean, who will all be speaking subsequent to my presentation. We also have Mr. Taylor, who has prepared a brief of planning evidence. He's produced a summary statement, which is being pre-circulated to the council this morning. He's available for questions if the panel has any. And I'm in your hands as to whether or not you would like him to run through his summary once I've finished submissions.
Okay, we haven't received an electronic copy of that yet, so.
We have got hard copies available for you as well.
Yes, that would be useful, thank you. And you've sent in electronic copies?
Yes.
Great. Okay, over to you. We have you allocated for an hour.
Thank you very much. My name is Catherine Forward. I am representing 4 of the landowners in the Lower Queen Street area. These submissions are made on behalf of those parties. The landowners that I represent own and lease land directly affected by Plan Change 79, specifically that part of Plan Change 79 that uplifts the present deferred industrial status to light industrial. My submissions include a couple of images. The first puts it in context for you that essentially the parties that I represent comprise all of the land that is included within the Lower Queen Street area that's proposed to be uplifted. There are 2 smaller parties. One, there's a carve out of that red block, which is the Flowerlands Limited. There's a smaller block within that, which is owned by the Tomsets, and you have Katrina Tomset here this morning. And the leasehold interests, James, you might have to assist me, but it's an MPI lease and also a cargo lease, which is right on the corner.
McShane's and
McShane's and Lower Queen Street Road. So that's just putting the land holdings in context. The second image there shows the overlay with the Schedule 17.4A area. The land proposed to be upzoned to light industrial comprises only some of Y-West's land holding. So figure 3 identifies the 3 titles owned by Y-West. And if you flick back to figure 2, you can see that there are some blue areas there that sit outside of the scheduled area. Figure 4 shows the land to be upzoned. And I draw your attention to the carve-outs, which exclude that land which is presently live zoned light industrial. Figure 4 identifies the extent of land proposed to be upzoned. When these figures are assessed side by side, it crystallises the issues for the management of Y-West's land. If Plan Change 79 is approved in its present form, Y-West's Lower Queen Street land holdings will be subject to 3 different sets of plan provisions. Rural 1 zone, which you can see on figure 4, is the pale yellow. The light industrial zone subject to the 17.4A overlay, which is the hashed area with the yellow dotted line. And then the balance is light industrial land, which is not subject to that overlay. Submitted that this proposed multi-zone overlay approach delivers a poor planning outcome, and this will be discussed in more detail in the site-specific section of my submissions. As I've mentioned, the Lower Queen Street land is presently zoned Rural 1 Light Industrial Deferred in the operative plan. The reasons for deferral are limited to available servicing connections for reticulated water, wastewater and stormwater. Pursuant to the infrastructure report prepared by Stantec, which was attached to the Section 42A or Section 32 report, one of those prepared by the Council, Stantec confirmed that those servicing matters have been dealt with and that the conclusion is that the land is suitable for upzoning. The landowners. Detail of the landowners and background to their contribution to the local community is set out in each of the submissions filed. For brevity, I won't repeat it. All landowners are attending this hearing in support of their submission, and as I've mentioned, some will address you separately subsequently. The landowners have collectively pooled resources to engage with Plan Change 79. They've lodged submissions, further submissions, and they've commissioned expert planning evidence together with legal representation. As I've mentioned, the owners of 17 Swamp Road, the Tomsets, have also submitted. They don't intend to speak to their submission this morning, but their submission does raise very similar themes to those from the Lower Queen Street landowners. Importantly, while the landowners support the lifting of the deferred status to unlock light industrial land use, their participation in this hearing is to ensure that the resulting provisions will facilitate viable development, and for Y-West will adequately manage reverse sensitivity effects on its existing horticultural operation. The landowners accept that coastal hazard risks must be adequately managed. However, they consider there may well be circumstances where this can be dealt with through site-specific mitigation measures. Plan Change 79 must deliver a planning framework that's compatible and consistent with neighbouring land use. To encourage investment and promote full utilisation of the upzoned land, it's critical that conditions imposed do not frustrate this land use. Choice is important, both to accommodate market demand, but also to provide options to investors and, in fact, to the council to develop in a way that allows flexibility to assess what's best for project and for the community. As proposed, land captured by Schedule 17.4A includes a wide range of elevations and its variable distance from the coast. When sea level rise modelling is assessed, this land is subject to a range of vulnerabilities to coastal hazards. It requires bespoke treatment, and a one-size-fits-all approach is not appropriate. Key regional infrastructure is located along Queen Street, including wastewater and water pipelines and stormwater management. The long-term plan provides funding in the 2024 to 2034 years to the tune of $5 million to upgrade the main water trunk line down Lower Queen Street. Hard maintained coastal hazard structures exist to protect existing businesses such as MPI, live zone land and community facilities. Council retreat from this area is unlikely. This stretch of Lower Queen Street is a servicing lifeline to the Richmond community and surrounds. The landowners consider that in some circumstances it may not be necessary for industrial activities and buildings to be temporary, relocatable and readily removable, where other mitigation, such as building up of land, specific design solutions or the construction of seawalls and other protection structures may be feasible and appropriate. Alternate measures to address the risk of future sea level rise, including storm surge, would of course need to be assessed on a case-by-case basis and be accompanied by supporting technical evidence to provide the necessary assurances. A resource consent process is the most efficient and effective avenue to provide for this, as it does not shut the door on innovation. It affords choice to the landowner, investor or developer to select a best for project outcome and ultimately reserves the decision-making to the council. The landowners are fundamentally opposed to a resulting planning framework that imposes development restrictions on their land holdings, where neighbouring land, subject to the same predicted modelled exposure to sea level rise, are not subject to these same constraints. Council's approach to enable built form and subdivision on land already live zoned is not consistent, and it prejudices the landowners. As I've mentioned, figure 4 above shows the carve-outs that have already been made for existing light industrial land. And if you look to the other side of Lower Queen Street, there is another area of light industrial. Evidence. The landowners have provided a brief of planning evidence from Mr. Taylor. If the panel would like, he will summarise his evidence and he'll address any additional matters raised from the council's recent reply. Content of submissions. The relief sought by the landowners, including the inclusion of an exemption pathway, which is intended to operate in parallel with the council's proposed provisions, and reasons in support are traversed in detail of the landowner submissions and Mr. Taylor's evidence. I ask that these legal submissions are read alongside those other documents, and together they present the landowner's case. My submissions will touch on scope to impose changes to subdivision rules in the Lower Queen Street light industrial zone, the application of the planning documents, risk and the appropriate response, and the relief sought, including site-specific considerations. Our submissions regarding subdivision as it relates to the Lower Queen Street area on Plan Change 79. It is submitted that due to the form and content of Plan Change 79 as notified, it's not open to the panel to consider the subdivision provisions relevant to the light industrial zone. Considerations regarding whether a submission is on a plan change are settled, and they derive from Clause 6, Schedule 1 of the RMA. The leading authority is Clearwater, expanded on in motor machinists. Case law is clear that if a submission is not on the plan change, then the council has no business considering it. The first question to answer is what is fairly and reasonably described in the scope of the plan change. This is because there can be no coherence and integrity in the process otherwise. It follows that a submission must be within the ambit of the plan change as notified, and it must not take things in a different direction. That respects the fact that the initiator, in this case the council, is not committed to a process of scale and scope that could not reasonably be anticipated when the process was initiated. The landowners contend that Plan Change 79 is not about limiting subdivision as it relates to the Lower Queen Street area. Rather, it targets the release of existing deferred land for development, provided adequate servicing is available and the zoning remains appropriate. Assessment of coastal hazard risk is of course relevant in this context, but it's confined to those parts of the plan that Plan Change 79 proposed to alter. Incidental or consequential changes are permissible, provided that no substantial further Section 32 analysis is required to inform affected persons of the comparative merits of that change. This procedural fairness consideration is particularly relevant, as notwithstanding that West has the benefit of a lease, Nelson Pine Industries as landowner and the Cargills are not submitters in this plan change. They may well have elected to do so had they known that limitations on future subdivision of their land may result. The first step to determine scope is to establish the purpose of Plan Change 79. This is described on the council website. I won't read through that, but I've set that out. Specifically, it does not include any comment on subdivision. The Section 32 evaluation report that accompanies Plan Change 79 is notified records that the overall purpose of Plan Change 79 is to amend the plan to introduce a new method that provides for a legally robust deferred zone framework and to release existing deferred land for development, provided the services are available and the rezoning remains appropriate. To achieve that purpose, the Section 32 report notes that Plan Change 79 includes, where relevant, the addition of new planning provisions for land that is subject to risks associated with climate change, including sea level rise, coastal inundation and flooding. The table on page 6 of the Section 32 report summarises the proposed changes to existing deferred locations that are included in the scope of Plan Change 79. There's no reference to any amendment to the status quo subdivision rules relevant to the Lower Queen Street land. Further, it's clear from the confidential council minutes appended to the council's Section 42A report that a prohibition on subdivision, which was advanced in an early iteration of Plan Change 79 by council planning staff, in the Lower Queen Street light industrial zone, and the staff were directed to remove these provisions prior to notification. The council was entitled to limit the scope of Plan Change 79. It consulted with the landowners and it recognised that the assessment of coastal hazard risk was best advanced on a case-by-case basis through the resource consent process. It was also noted at this time that the rules should be the same across the region. While the Section 32 report contains isolated references to limitations on subdivision within the light industrial zone and within the Appendix 5 schedule of amendments, these have been acknowledged as an error and is likely the result of revisions being made to the Plan Change 79 package following the council's decisions to remove any amendment to the status quo subdivision provisions relevant to the Lower Queen Street land. As notified, Plan Change 79 does not propose to change the operative Chapter 16 general rules as they relate to subdivision. Changes are limited to the closed commercial zone in Marahau. This contrasts with changes proposed to the 17.4 industrial rules, specifically those that introduce new and amended land use and building rules that apply to the scheduled area. The Section 17.420 explanation that accompanies the rules also does not reference subdivision in the new text specific to the Lower Queen Street light industrial zone. The Section 32 report does not include a cost-benefit assessment to address the option of limiting subdivision within the scheduled area. There's no evidence to support the council recommendation that the risks posed from coastal hazards outweigh the financial impacts that prohibiting subdivision will impose on the viability of development and the economic well-being of the landowners. Instead, the assessment focuses on the proposed restrictions to land use and built form development. The landowner submissions support Plan Change 79 as notified, which specifically does not include a prohibition on subdivision. The submissions of Jenny Easton and the Nelson Tasman Climate Forum raised the issue of restrictions on subdivision in the relevant area. And these are set out in the Section 42A report. It's reliant on these two submissions that the Council reporting officers recommend a departure from Plan Change 79 as notified and advance a new position that seeks to prohibit subdivision within the scheduled area. In taking this approach, the officers undermine the direction of Council as per the decision recorded in the Confidential Strategy and Policy Committee minutes and the scope of Plan Change 79 as notified. It is submitted that for the reasons outlined above, neither of these submissions were on Plan Change 79 as notified, and therefore the Council officer's recommendation to prohibit subdivision in the scheduled area is an error of law. In the alternative, if the panel do not accept the submission that the subdivision as it relates to Lower Queen Street area is out of scope, the correct activity status ought to be restricted discretionary for the reasons outlined in Mr. Taylor's evidence. The Council's blunt approach to prohibit subdivision is inconsistent with the higher order framework. A restricted discretionary activity would enable Council to impose matters of discretion to appropriately manage coastal hazard risks through conditions of consent, and Council could decline an application in certain circumstances. It is entirely inappropriate for the Council to introduce a prohibition on subdivision when it is advancing a broader district-wide natural hazards plan change. This plan change to come will be informed by the National Policy Statement for Natural Hazards, which is presently in development. This may find that a prohibition on subdivision is not the most effective and efficient response. Dealing with subdivision on Lower Queen Street in advance of the wider plan change is inequitable and pose a significant risk to the Council of getting it wrong. It is submitted that the sensible approach is to leave any assessment on subdivision to the second tranche review. Application of the planning documents. While Mr. Taylor and the Council reporting officers agree on the planning documents relevant to Plan Change 79, they disagree on how they ought to be interpreted. In particular, the Council reporting officers focus on the term avoid as it exists in Policy 25 of the New Zealand Coastal Policy Statement, Objective 5.2 and Policy 5.2 of the Tasman Regional Policy Statement and various provisions of the plan as justification for why a prohibition on subdivision is appropriate. This approach fails to acknowledge settled case law that objectives and policies cannot be read in isolation and must be read together as a whole. When read in this way, it is clear that it is not the subdivision, land use and development activity itself that is to be avoided in areas prone to coastal hazards. It's the avoidance of any increased risk. As Mr. Taylor points out, the guiding planning framework enables a range of responses to address coastal hazard risks depending on the circumstances. There is no blunt prohibition directive. Mr. Taylor's evidence confirms that the Coastal Policy Statement provisions are embedded in both the Regional Policy Statement and the plan, as the latter has been updated to give effect to it. As the Regional Policy Statement is an earlier document, it's helpful to acknowledge that the Coastal Policy Statement 2010 was replaced in earlier 1994 version, which also included policies addressing appropriate subdivision use and development of the coastal environment, provided that adverse effects were avoided, remedied or mitigated. It is submitted that the concepts of mitigation and remedy, which could incorporate the site-specific mitigations to protect against predicted sea level rise, serve to meet the avoid standard by reducing the level of perceived risk. Notwithstanding that the plan is not considered to be invalid or incomplete, the Port Otago Supreme Court decision confirms that where inconsistency is perceived in higher order documents, this ought to be reconciled as a priority. And this is best dealt with at the Regional Policy Statement and plan level as far as possible. While noting its decision does not revert back to the overall judgment approach rejected in King Salmon, the Port Otago decision does introduce a certain gloss that directs the panel to carefully analyse the factual circumstances when striking the appropriate balance and in turn selecting the most efficient and effective planning outcome. The discussion above is relevant to the panel's determination as to whether a prohibition on subdivision in the Lower Queen Street area is warranted based on the available evidence regarding modelled sea level rise, the timeline in which that may give rise to adverse effects, and what options are available to manage those risks. The concept of risk. Our knowledge of climate change continues to grow, and it follows that the risk profile of sea level rise occurring as modelled and the attached timeline is not hard and fast. The planning response must be commensurate of the risk posed. It is submitted that a certain level of flex must be built into the planning regime to enable subdivision, land use and development to adjust as both knowledge improves and the national guidance evolves over time. An example of this is the methodology informing the identification of the sea level trigger that once reached will elicit various planning responses within the scheduled area. The trigger, while promulgated in science, includes a number of limitations and assumptions that impact the consequences of modelled sea level rise at the Lower Queen Street site. These are outlined in Appendix 4 to the Section 32 report and include: there's no gauge at Lower Queen Street and tide recorders at other locations have been used. It's assumed that sea surface height is the same between Lower Queen Street and both the Little Kite Area and the Port Nelson tide gauges, and there is limited understanding of wave setup in the Waimea Inlet. Based on the above, the science informing identification of the trigger is conservative at best and potentially inaccurate. The bathtub modelling adopted by Council to measure potential sea level rise has been subject to scientific scrutiny. It is submitted that for these reasons, the panel ought to err on the side of caution at the risk of getting it wrong and enable subdivision in the scheduled area to continue for the time being. There is no certainty how many years it may take for sea level rise to breach the existing protection structures, and or whether these may be built up, made more resilient once Council has completed its 10-step decision making to achieve an adaptation plan as required by national direction. As Mr. Taylor points out, Policy 27 of the Coastal Policy Statement recognises that protection structures may be the only practical means of protecting existing infrastructure of regional importance, such as the MPI industrial facility and Three Waters infrastructure along the Lower Queen Street Reach. The Section 42A report alleges that the landowner's proposed exemption pathway will expose the Council to increased liability. This is manageable, and there are mechanisms available to minimise Council exposure. An important consideration is that the scheduled area is earmarked for industrial use, not residential. Buildings are to be relocatable and readily removable. If desired, Council can require development to occur pursuant to an outline development plan, and it's common for internal infrastructure to be maintained privately. The reticulated network in this location already exists, and the reality is that the land use footprint will be no different whether subdivision is provided for or not. Further coastal hazard risk goes hand in hand with the Building Act, which governs new buildings, and land information and project information memoranda assists in property purchases and consent processes. Mr. Taylor's evidence traverses several levers that already exist to mitigate against coastal hazard risk, including those contained in the operative light industrial zone rules, such as raised building platforms and considered stormwater drainage. Section 106 of the RMA gives the Council the ability to decline consent where there is a significant risk of natural hazards, the inundation practice notes that the Council relies on, and the use of consent and hazard notices under the RMA. It is submitted that these solutions, together with the landowner's proposed exemption pathway, ought to be preferred over a blunt prohibition on subdivision. Relief sought. Mr. Taylor's evidence sets out the relief sought by the landowners, including the proposal for an exemption pathway in relation to limited consent durations and temporary relocatable buildings. The exemption pathway is proposed to operate as an alternate option to the Council's prescribed regime. It's supported by a new policy, which would allow a different development approach, provided it is accompanied by expert technical assessment and support. Importantly, this does not water down the Council response to coastal hazards. It simply provides for site-specific treatment of risk where it is available. The landowners also seek revisions to the Council proposed version of Plan Change 79 to improve application of the land use and building rules, to ensure an efficient and effective planning outcome. The landowner's submissions comprehensively address the requested drafting revisions, and Mr. Taylor has promoted some additions in his evidence, namely a restricted discretionary status for subdivision rather than the controlled activity status, which is what the operative provisions provide for, along with a 2,000 metre squared minimum lot size within the new light industrial zone. The interplay of the scheduled area with the wider light industrial zone is critical to the zone's function and to it being able to deliver the needed business development capacity to the district. Ambiguity in the plan framework has the potential to undermine the operation of the upzoned land, and it will also disincentivise investment. Two examples that presently invite interpretation challenge are the council references to short, medium and long term with no accompanying definition to confirm what these time periods are, and the requirement for a plan to be developed by a consent holder to address how buildings are to be physically and financially removed from the sites. The landowners seek that both references are deleted to improve operation of the provisions. The following part of my submission deals with site-specific relief. Mr. Brett McLean will speak to the site-specific relief requested by the AB and SL Family Trust. A prohibition on subdivision will undermine the significant investment made by the trust to develop its land. This relief is only necessary where the panel determine that subdivision ought to be prohibited in the scheduled area. If it's enabled as per the status quo light industrial provisions, then this submitter would be entitled to make an application for subdivision once Plan Change 79 becomes operative. Y West, to address the poor planning outcome that results from dissecting the Y West land with 3 separate zones overlays, Y West has sought to rezone its balanced record of titles from Rural 1 to Light Industrial and/or seeks to remove the Schedule 17.4A overlay from its land. Schedule 17.4A does not reflect cadastral boundaries, so Plan Change 79 in the form recommended by Council would extend a prohibition on subdivision over the balanced Y West land, as well as that included within the scheduled area. This cannot be what was intended. The Council reply suggests that there may be some room to rationalise or square up certain edges of the mapped area where that would improve practical implementation. I understand this to be general agreement with the proposal to exclude Y West land from the schedule area and encourage the panel to seek confirmation of this from those in the Council technical team. Y West's freehold land is the furthest from the coast. Sea level rise modelling indicates that this land will be affected by sea level rise much later than land closer to the coast. This variability reiterates the importance of a planning regime that accounts for and responds to this. As presently drafted, the plan change fails to acknowledge this distinction and effectively penalises Y West by imposing a restrictive regime, while the actual risk of inundation on Y West's land may not be yet realised immediately on breach of the sea level rise trigger. It's also important to acknowledge that when you consider the sea level rise modelling maps and the incremental stages of sea level rise, the key issue for the Lower Queen Street area is the storm surge, not the mean high water springs, which does stay outside of the scheduled area. So that's what we're protecting against. There's infrequent storm surge events. Yalberton. As above for the Trust, Coral and Tracy Yalberton seek consequential amendments to Chapter 16.3 to ensure that subdivision of the existing dwelling at 587 Lower Queen Street is provided for, preferably as a controlled activity. The Yalberton land neighbours existing light industrial land, which you can see from Figure 4. As for the Trust, this relief is only necessary if the Council advance a prohibition on subdivision. Flowerlands. This submitter requests acknowledgement within Plan Change 79 that recontouring land within the scheduled area is appropriate site-specific mitigation to manage modelled coastal hazard risk. This is what has been undertaken at the Coman land, which you will see from your site visit. Again, this relief would operate within the landowner's proposed exemption pathway It's allowing a site-specific assessment to be completed with supporting technical evidence to ensure that viable development results. Conclusion. Despite evidence presented by Mr. Taylor, the council continue to promote a prohibition on subdivision in the scheduled area, citing future costs and risks to landowners, constraints to adaptation pathways, increased pressure for hard protection measures, and interference with the natural ability of the coastal margin to retreat over time. No evidence has been provided by the council to support these claims. In contrast, the landowners who will be responsible for the success or fall of the upzoned Lower Queen Street Light Industrial Zone request flexibility to select a development option that responds appropriately to coastal hazard risk, but does so in a way that allows site-specific solutions. A blunt planning approach does not enable adaptive management. That concludes my submissions. I'm happy to take questions on those now or following the presentations from the landowner parties.
No questions of you at the moment, Ms. Ford. We're happy to move to the landowners.
Thank you. Would you like to hear from Mr. Taylor in terms of his planning evidence?
I've got you allocated for another half hour. What's the best use of time, do you think?
I think Mr. Taylor has prepared a really short summary, so I think we will be able to get through everybody who wishes to speak within half an hour.
Mr. Taylor, if you'd like to circulate your summary, please. Okay, Mr. Taylor, we have obviously your evidence already provided and we've just read your summary if you want to take us through your summary. Thank you.
Thank you, Commissioner. The submissions made by the group of landowners from the Lower Queen Street RW1 area generally supported the plan change but sought greater flexibility than provided for by the proposed land use rules in relation to duration limited consent and removable relocatable buildings. The key tension between the submissions by these landowners and council officers relates to the management of coastal hazard risks. In particular, the introduction of proposed rules prohibiting subdivision in parts of the RW1 area. Council officers consider that national direction necessitates a prohibition on subdivision and also the proposed land use controls. My evidence reviewed the relevant national direction and concludes that it does not necessitate the provisions proposed by council officers. The council officer's position on this appears to be premised on interpreting the national direction as saying that new development should be avoided where a natural hazard or potential hazard exists. I disagree and consider that the national direction expects that development should be avoided where it would increase natural hazard risk. As detailed in my evidence, there are ways in which risk can be avoided, remedied, or mitigated. This is routinely addressed through detailed design based on expert assessment accompanying resource consent applications, and I've provided examples in my evidence demonstrating this. To conclude that all longer-term activities or subdivision within areas potentially prone to natural hazards are contrary to the coastal policy statement and the TRMP is, in my opinion, an untenable position. To reach this conclusion, it would have to be accepted that any resource consents that have been granted by council for such activities should not in fact have been granted. I also consider that the council officers overstate the significance of subdivision compared to land use activities. Irrespective of whether subdivision occurs, development of the plan change area will involve intensified land use, multiple interested parties, such as leaseholders, and provision of infrastructure. I do not consider that subdivision creates additional risk or effects in relation to natural hazards. My evidence concluded that the existing policy regime relating to management of natural hazards as well as other mechanisms available to council to address these hazards, provide an adequate framework to enable assessment and management of risks on a case-by-case basis at resource consent stage, and provide council with sufficient ability to refuse consent where necessary. Council officers note that the council is in the process of addressing natural hazard management through a broader district-wide plan change. They acknowledge this involves working through the 10-step adaptive planning process set out in the MFE guidance, but this process is currently incomplete. I do not understand the purpose of implementing a bespoke and highly restrictive framework for this one site that has not followed this MFE process guidance, and which has been exposed to little public scrutiny in advance of the district-wide process. Essentially, the RW1 land is zoned for light industrial activities. Its deferment relates only to the provision of services which are available, and it's not at greater risk of natural hazards than some other areas of light industrial zone land around Richmond and other coastal locations in the region. I consider that a suitable framework already exists to manage natural hazard risks if the deferment notation is removed. However, I'm supportive of additional provisions relating to natural hazards, provided they enable adequate flexibility to account for site-specific circumstances and expert assessment. I support the council's district-wide approach to managing natural hazards. If this process results in additional provisions relating to natural hazards, then so be it. I simply don't think that the current plan change process is the appropriate one under which to promulgate these. My evidence confirms I generally support the relief sought in the submissions of the Lower Queen Street landowners, but details some suggested changes to TRMP provisions to address the concerns of council officers. Happy to take any questions if you have them.
Thank you, Mr. Taylor. I'll just see if we have any questions. Now, Ms. Ford mentioned that you are going to traverse section 106 of the RMA with us.
That's detailed in my evidence. I'm happy to touch on that again if you like.
If you'd just like to provide an overview of section 106 and what that provides.
Sure. So essentially for any subdivision application that council's considering, council needs to turn its mind to section 106, and section 106 says that council should not grant subdivision consent if, I'll just get the exact wording, bear with me. If there is a significant risk from natural hazards, or sufficient provision has not been made for legal and physical access to each allotment to be created by the subdivision. And so both of those need to be satisfied for council to grant subdivision consent. And the provided example of my evidence of where council have turned their mind to that in a very similar situation for a light industrial subdivision recently at Artillery Place. And in that circumstance, council, on the basis of expert assessment, were satisfied that those tests of section 106 were met and were able to grant consent. There may well be other circumstances where council aren't satisfied with that, and I've certainly had experience of having that council take their position with proposed subdivisions. So I think it's a very strong mechanism that council has at their disposal to resist subdivision where necessary.
Have you been keeping up with the latest resource management amendment bill?
I'm aware that the government's considering extending a similar mechanism for land use activities. Is that what you mean?
Yeah. Okay, thank you. How would you define natural hazard risk? So in your paragraph 4, that national direction expects that development should be avoided where it would increase natural hazard risk. What does natural hazard risk mean?
Well, I think it's the intersection of a potential hazard with with a possibility of harm from that hazard. So there's circumstances where risk can be mitigated or avoided, even where a hazard exists. And that's quite commonly addressed through a resource consent process.
We heard from the council officers that they were concerned particularly about additional landowners being resultant from a subdivision, but also the infrastructure that would be put in place. So how would you respond to the council's concerns?
Well, as part of a resource consent application, there would be detailed, concept design at least of infrastructure provision that's associated with subdivision or development. And that would be considered through the lens of hazard risk management in the same manner that the potential activities on that land would be. So there are ways that risk could be mitigated through a design process. For example, roads being on raised land, infrastructure within those road corridors being within raised land. I think it's relevant in this circumstance, in this for this land, that the servicing provision is all from the landward or uphill side of the development area, and so it's not relying on drainage, for example, towards the lower parts of the site, which makes the design of those elements more practical in avoiding those risks. There's also the potential for private assets if council don't want to take those on through the process of vesting. Yes, I think there's options available, and the fact of the matter, and probably the point of much of my evidence, is that it seems like a poor outcome to preclude any of those options at this stage through the plan provisions.
Thank you, Mr. Taylor. Just one final matter which Ms. Ford might want to chime in on as well is how much weight should the panel give to Ministry for the Environment guidance or any other guidance material?
Yeah, probably defer to Ms. Ford on that, but I mean, it is guidance. It needs to be had regard to, I would say, but possibly a lower threshold than the likes of a national policy statement, or leave that to you.
No, I agree with Mr. Taylor. It is guidance material. There's case law that tells us that we must be looking at the words of the documents rather than the guidance material to enable us and to assist us interpreting the higher order documentation. So I do urge you to look at the words of the provisions. The guidance material is helpful to provide context and understanding, but you ought not to be providing sufficient weight on that.
No further questions for you, Mr. Taylor. Thank you very much.
Thank you. There are 3 landowners who wish to speak, so I might start in order of my submissions with Mr. Brett McLean for the ABNSL Trust.
They got copies of these are slightly out of date. Alan's name on them?
No,
that's okay.
Make
There's that.
one minor correction. Mr. Alan McLean's name is on this document, but it's actually Mr. Brett McLean who is reducing you this morning.
Hey, welcome, Mr. McLean.
Thank you. Yes, my name's Brett McLean, and we have the property at 563 Lower Queen Street. We produced a map which shows the yellow outline of our property, which is opposite the MDF plant. And we're seeking the fair opportunity to develop the land. And we've seemed to have been caught up in these ongoing planning hurdles over the past number of years. The development proposal, our intention is, or was back in 2021 when we put our application in, was to erect a large commercial size building to support our medical equipment business, which is Oprotec. It would have administration office, staff rooms, facilities, and handle logistics of medical equipment. Intention was to subdivide the overall property into about approximately 5 lots to release capital for the development. The plan change initially appeared to provide opportunity to progress our development. However, the recent plan reports introduced new hurdles that make development incredibly difficult, even if the property is zoned industrial. With this change, grappling with the concept of development without subdivision is difficult and seriously undermines the progress and cost we've incurred to date. And I don't know quite how we go ahead with that. The next figure over the page is our scheme plan. So this is provided to the council as part of our uplift application in 2022. It was in concept. We were required to provide extensive technical information to demonstrate the feasibility of servicing this layout and other potential options I'll discuss further down. But it was not until we incurred the cost of providing this technical information that the council staff advised that they would not progress the uplift application. I guess the key thing is that we want to see that our work and effort to date is not wasted. We'll just skip down to the application history because I think that's important to us. So over the page in 10.1, just to set the scene, the property above, which is a DT King CVC property, joins our property. That was subject to an uplift application, which was granted in 2021. At that point in time, we weren't in a position to proceed with our application. The building platforms on the DT King site were raised to RL 4.6 and had the same infrastructure requirements as our site. We commenced our consultation with council on our own uplift application in August 21. Communication in early February and to April 2022 identified stormwater as a potential issue for uplift. We've been given authorisation to utilise Tonkin Taylor modelling applied to the King property to assess our property. In July 22, AMK engineers completed a stormwater study report applying that previous modelling. In August 22, the application for uplift was lodged with council. In September 22, we received feedback from council staff, which included notice that council was rerunning stormwater modelling to come up with a viable solution for the site. In October 22, we advised that Tonkin Taylor had been engaged by the council to model the two-flow area. The model was available for our stormwater specialist to rerun specific development options. In November 22, we were provided with the Tonkin Taylor modelling assumptions to be applied to the future modelling. But we were also advised at that time that the council did not consider AMK engineering to hold the expertise to further this modelling exercise. In February 23, Matt as a pro consultants were engaged to undertake the requested modelling. This modelling was provided in February 23, and the draft reports circulated to council June 23. July 23, council requested additional information in relation to modelling. However, the council also advised there was a work stream around deferred zoning, and the decision on the application would need to wait the outcome of that process. Following further queries, the council advised that they presumed we were aware of that our application couldn't progress. We were advised that this had been the case for some time. We were completely unaware of the stance taken by council. I've provided this timeline just to demonstrate the extensive work undertaken at the request of council, only to be told that what we thought was the last hurdle, the uplift could not proceed. In a similar vein, we thought that Plan Change 79 proposed a somewhat practical means of providing development potential. Our our consultation with council officers in advance of this plan changes notification was that prohibition on subdivision would not work. We were pleased when the plan did not restrict subdivision in this way. However, we've now been surprised with council officers' report, which fundamentally departs from the notified version. I don't understand why these matters weren't resolved internally within the council. Ultimately, this is not a facilitative plan changed as was notified. By advancing prohibition through the council officer report, we've had little opportunity to respond comprehensively. We've sought to engage additional technical consultants to progress this work. They have not been able to do so on the short timelines between the receipt of the planner's report and this hearing. So I guess in essence, we feel quite blindsided and frustrated by the effort that we've put in, working to all the things instructed by the council, only to be turned down right at the end. Obviously, we want this planning regime to fairly assess the merits of our site. We've progressed extensive assessments on this already for the council. I think an appropriate example of development is the one we already mentioned at Artillery Place, where site-specific mitigation is provided along with the latest information. This is the methodology accepted by the council previously and proven to work. That's me.
Thank you, Mr. McLean, for taking the time to prepare and read through your statement. I'll just see if we have any questions. No questions. You've been very clear.
Thank you. On behalf of Waiwest Horticulture Limited, James Patterson will now present a brief summary statement, and I've also got copies of those to pass around as well.
Firstly, thank you for your time this morning. My name is James Patterson. I'm the Managing Director of Waiwest Horticulture. Waiwest Horticulture is jointly owned by 3 families and have been operating the top of the south since 1983. Our company owns or manages approximately 220 hectares of horticultural land in the Tasman district. We grow apples, boysenberries, kiwi fruit, and some feijoas. We employ around 40 permanent staff, with an additional 250 seasonal workers on fixed term or casual contracts during the growing season. These workers are made up from New Zealanders, RSC workers, and individuals on working holiday visas. Waiwest Horticulture owns the property at 33 Swamp Road. It's shown on the attached map, and leases land at 491 Lower Queen Street and 16 Shanes Road, as shown.
We get sent through this with colour.
Oh, sorry.
On it.
Yes, you
Be
can.
helpful. Thank you.
Waiwest Horticulture seeks a fair and balanced opportunity to develop its land. We also seek to ensure that our existing horticultural operations can continue until light industrial development becomes financially viable. While the plan change initially appeared to offer a genuine pathway to progress development, the recent planner reports have introduced new obstacles that significantly hinder that potential, even with the industrial zoning in place. The expectation to develop without subdivision is particularly problematic. At this stage, it is unclear how development could realistically proceed under these conditions. Landowners require flexibility on how they manage coastal hazard risks on their properties. An exemption pathway is essential to provide flexibility and allow for tailored solutions where landowners are willing to invest in appropriate measures, supported by expert assessment. The plan change should ensure consistent and equitable treatment between land that has already had its deferred status lifted and land within the scheduled 17.4A area. Plan change must enable viable development opportunities both within and beyond the scheduled 17.4A area. It's the council's responsibility to ensure there is a clear and practical pathway that encourages investment and supports the intended purpose of its upzoned land, without imposing conditions that unduly hinder the proposed activities. Waiwest Horticulture would expect development to occur in stages, aligned with the demand from the Tasman and Nelson city districts, Initially, development would most likely begin as an extension of the existing Commons development along the eastern boundary of Wairau land. The southern boundary of Schedule 17.4A area intersects multiple property titles and appears to have been drawn based on the 5.1 metre ground contour. Although that is not clearly explained in the notification documents, given that different land use rules apply within and outside this area, complications may arise for properties that are only partially covered within the schedule. To address this, we request the boundary be adjusted to either align with property boundaries where they are close to the 5.1 metre contour, or allow the land within the schedule area is raised above 5.1 metres as part of the development process. The planning provisions apply outside the schedule may also apply to the raised land within it. The building restrictions as currently notified may discourage investment in light industrial development, potentially undermining the intent of the rezoning. We consider that where an applicant provides comprehensive information, including expert assessments as required, there should be provision for industrial buildings that are not necessarily temporary, relocatable or removable. At a minimum, a clear consent pathway should be available to enable such developments to be considered on a case-by-case basis. Wairau Horticulture initially understood that Plan Change 79 offered a practical approach to enabling development. Prior consultation with council offers indicated that a prohibition on subdivision would not be workable, and we were encouraged to see that the notified version of the plan did not include such a restriction. However, we are now surprised by the council officer's report, which represents a significant departure from the notified version. Wairau Horticulture is the largest landholder within the RW1 area. The maps above illustrate the scale of horticultural activity currently undertaken by the company in the Richmond West area. This parcel of land is also the furthest inland within RW1. As currently proposed, the trigger point would affect all landowners simultaneously. However, in practice, this is unlikely to be the case. A staged approach with multiple trigger points would provide greater flexibility, allowing landowners to manage and mitigate inundation risks as they become relevant to their specific properties. A relevant example of appropriate development is the Artillery Place application, which demonstrates how site-specific mitigation can be effectively implemented in accordance with the most up-to-date information. This approach has previously been accepted by the council and has proven to be successful in place. Thank you for your careful consideration of this matter. A workable and robust solution must be achieved that serves the interests of the Tasman District Council, landowners and the wider business communities of both Nelson and Tasman. Thanks.
And again, no questions for you, Mr. Patterson, but you certainly have raised a few questions that we will be putting to the planners in due course. So thank you very much for the time that you've taken to prepare that and present to us.
Thank you. One final landowner to present to the panel, and that's Mr. Stuart Flaude.
And firstly, I apologise because I've only got some notes to read to and I haven't copied them, but I can provide my notes later on.
That would be helpful, thank you.
As landowners of deferred industrial land, we brought with a long-term view of subdivision industrial rentable buildings for a passive income into retirement. We're happy to see the progress being made on lifting deferment, but extremely concerned about the possible no subdivision provision and the removal buildings and the abandonment of land at some trigger point. This seems a dramatic approach with no thought to mitigation or innovation of building. While I understand the planners' thoughts and concerns, as a builder, I see opportunity for solutions. In my opinion, it would create an industrial area the same fashion as a caravan park for living accommodation. Lower class and not anything we could be proud of or that the council should encourage. That is, if we can't subdivide our land and we have got to build transportable or removable buildings, it's just going to be like a caravan park. Whereas paying to do it properly, there would be a subdivision of similar standards to the estuary, Gibbons and Comins. The value of the land would be greatly reduced if it can't be subdivided. Most small industries would be seeking smaller parcels of land. Very few operators require parcels of lands like trucking companies. Buildings that are transportable and removable are generally more expensive to build, limited in their end use, and more prone to damage if water was to enter. Concrete is a more durable, versatile, and if water did ever enter 4 or 5 times in its lifetime, would do little to no damage. Raising the land level would be a relatively small cost, about $65 a square metre would raise the land a metre. That would be less than 10% of the finished section price. It would make this land suitable for long-term industrial use with minimum risk to the council and could be done over time using recycled material. While sea level rise is something the next generation may have to deal with, we can use forethought and preventative measures with building and engineering innovation to prevent or maximise it, to minimise the effect that this would have on the land. And if I just digress it, but some years ago, a lot of people here in this room would remember that Tahuna Beach was being eroded at an alarming rate, and they were worried about it. It was an innovative approach to engineering that tunnelled the creek that came out there alongside Rocks Road, and we see that nature has taken its own course and rebuilt Tahuna Beach, and that is innovative engineering. We note that Ravensdown in the council maps has a bund stop wall around it. Nelson Pine has a reinventment wall protecting them from sea level rising. This leaves 580 metres between them. By constructing similarly along the head of the estuary, it would prevent or protect the cycleway, Lower Queen Street, the infrastructure that is in council-owned infrastructure in Queen Street, and approximately 40 hectares of land. We note that the climate report from Nelson Airport suggests that a stone wall to mitigate rising sea level. By recycling hardfill from the Nelson area, our properties could be raised. It is my understanding the deferment of the Drummond block, which incidentally has been raised, and then the deferment lifted, and that land level is now at approximately 4.5. And that in itself is going to mean that the sea is going to be stopped at that point or restricted. And Commercial Vehicle Centre have both had their deferments lifted without a non-subdivision rule attached. And the finished floor level, as Brent alluded to, in that building is 4.6. And I believe that if it's good enough for our neighbours, it should be good enough for us. That's my take on it.
Mr. Flatter, in your evidence, you've quoted the Gibbons development in Lower Queen Street.
Yeah.
Are you aware that that's on one title?
I'm aware that that's on one title, but I don't have Gibbons's legacy of wealth behind me.
Thank you.
And we wanted the right to be able to subdivide so that we could sell some of the sections to fund building other buildings. that Gibbons development gives us a beautiful picture of what can happen when a lot of that was filled with recycled concrete and fill.
Okay, thank you, Mr. Flowerday. If you could please provide your notes, that would be very helpful. Just before we close with you, Ms. Ford, I have been looking back at the submissions and in particular that of the Nelson Tasman Climate Forum, who have specifically stated that they strongly support limitation or prevention of subdivision on properties. Do you not consider that that submission point provides scope for the council to consider a change of activity status for subdivision?
Only if the panel determines that that submission is on a plan change which provided scope. And my view is that as plan change 79 was notified without any prohibition on subdivision, any submission that seeks that is out of scope.
We'll be asking the council to provide their view on that to us before we make a determination on that. Now, just before we close and go to morning tea, did you have any final comments you wanted to make, Ms. Ford?
No, I don't. Thank you very much for your time.
Thank you. I will now adjourn for morning tea and we will reconvene at 11:15 and we will be hearing from Ms. Jepp for Appleby and Mount Hope. So thank you, everyone. Thank you for your time this morning. Okay, we will reconvene, and we are now hearing from Mount Hope Holdings Limited and Appleby 88. We have your legal submissions. Thank you very much, Ms. Gett. How would you like to proceed? We have you down for half an hour.
Thank you, Commissioners. What I thought I would do is just try and incorporate what I've heard this morning from the council officers and into where that leaves us with respect to my client's preferred relief. So I'll go through my submissions, but I'll go through the parts of my submissions that address changes that are sought, but I will try and incorporate what I've heard from the council this morning as I do so. So I've got Mr. Davies with me, but he's not proposing to speak, but he is able to answer questions if you have any questions for him. Are you happy for me to go ahead in that way? Thank you. So just to introduce my two clients and their key interests, for Mount Hope, it's essentially, the issue is essentially that being a deferred site in Mapua, it has now been excluded from Schedule 1714A. It says with no scope for that to happen. And its relief is that it is reinserted back into the schedule, or if that doesn't happen, then it needs to ensure that the provisions that apply to deferred sites that aren't in the schedule are appropriate. What we've heard from the council this morning on that is that the intent, or that site has been identified or recommended to be rezoned through the Mapua planning process, and that does take some of the, I suppose, take some of the heat out of the issue, but it doesn't change the fact that while this plan change purports not to impact Mapua sites, it clearly does impact Mapua sites. In fact, in this case, it has literally put a line through this site in the schedule. So the relief remains, notwithstanding the indication from council, which is welcomed, that the site has been recommended for medium density zoning through the Mapua process later this year. For excuse me, for Appleby 88, the interest is slightly different. It's a site that is within the schedule, so it is interested in ensuring that the provisions of the plan are appropriate in two scenarios. The one is where it decides to proceed through an application for resource consent to develop the site in advance of any triggers for urban zoning provisions applying to it. And the other scenario is that scenario of what are the triggers that lead it to have a different planning framework apply to it, albeit that the zoning is not changing. So in some senses, my perspective is that the plan change has not clearly distinguished between those two scenarios, between provisions that apply to a resource consent that is lodged in advance of triggers being met, and to the second question of the trigger itself that this plan change is seeking to protect while addressing the legal uncertainties of the previous framework. So that's those are the scenarios that I've addressed at paragraph 8 of my legal submissions. I'm only going to very briefly address you on the lawfulness of the new framework, but I'm happy to answer any questions about that you have. My submission is that the approach that council is proposing now is lawful. It is not. There's nothing inherently wrong with a deferred zoning concept. The issue is really just that problem of essentially a change in zoning happening without a Schedule 1 process. That is not an issue that arises with what the council is now doing, and therefore some of the plans that have been referred to, for example, in Mr. Percy's evidence for the tallies, are not really relevant because they are dealing with that change of zoning framework that has been discounted. So that's not what's happening here. Therefore, the question becomes, is the framework that the council is now proposing sufficiently certain? And in my submission, it is. It is largely going to require, is largely going to result in some sort of resource consent process in order for anything to change on the property anyway. And that resource consent process enables the analysis of which provisions of the plan apply. So in addition to the schedule already specifying that these are the provisions that apply before, these are the provisions that apply after, these are the steps that change from one set of provisions to the other. In addition to doing that, the reality is that there's likely to be a resource consent process where an applicant is going to say, these matters are satisfied, therefore this set of provisions applies. If the council disagrees with that, it is open to the council to say that they don't think that has been met and that the site is not within that scenario. It hasn't met that trigger. So really the position I take is that to the extent that there is some uncertainty, it's not to the it's been overstated in Mr. Percy's evidence, and the residual level of uncertainty is something that is inherent in plan rules on a regular basis. And I've given the example of regulations or rules that depend on the determination of whether a feature is present. That may require analysis. It may be something that is the subject of different views, but that is still a valid rule as long as there are provisions or criteria in place to enable that assessment to happen.
Are you happy for questions along the way?
Absolutely,
or...
yes.
So did you read Miss Tancock's submissions?
Yes.
And in submissions, she refers to like the Queenstown case and Auckland case, but are those actually comparable to a deferred zoning framework?
Well, those are two that I was mentioning where they are a change in zone as opposed to a change in rules applicable within a zone. So I think they are more they more indicate what this plan, what the operative plan does than what is now proposed to happen. Equally, she also gives examples of the proposed Waikato and Waipa district plans, and I've had a look at those and they both appeared to be discounted because they enabled a change of zoning as per the operative plan rather than what is now proposed in this plan.
Did you have a look at any other plans about what frameworks they use?
No, I haven't. No, and I'd be interested to see what the council has done about that. But no, I haven't gone beyond the ones that were identified there. The only other one that I had looked at was the, well, not the plan itself, but the case, the Muir decision that I've referred to, where a similar a rule that applied on a temporary basis was considered to be acceptable, albeit that it was ultimately not upheld, but that was for different reasons. It wasn't because of its temporary nature.
Okay, please proceed.
Thank you. So I'm going to pick up then that's all I really wanted to say about the deferred concept, subject to any further questions you may have. So I'm going to pick up from paragraph 26, where I'm dealing with the Mount Hope Holdings property and its reinsertion. The issue being that this site overall was included in the operative version of is included in the operative version of the schedule, and it has been struck through in the plan change version. There is no suggestion that this site shouldn't be a deferred zone. It is still proposed to be a deferred zone. It's just not in the schedule. And my submission is that it is clearly within the scope of this plan change because it has been struck through. That is a change from the status quo compared to what the operative plan does. So despite the plan, there are statements throughout the planning documents purporting to exclude Mapua from the scope of this plan change, but the change that the plan makes to the status quo does affect this site in Mapua, and it is therefore within the scope of the plan change. All that the submission is seeking with respect to the schedule is to maintain the status quo by keeping it within the schedule. So I can't see any basis on which it can be said that that is outside of scope. As I said at the outset, while the indication of where things are heading for the Mapua planning process is welcome, the relief is still sought that site is reinserted in the meantime. That deals with that issue, and that takes me to paragraph 38. So if Mount Hope's land is not included in the schedule, then the way in which the plan change addresses those non-scheduled deferred sites becomes critically important. And I acknowledge that the council has sought to move this plan change along a lot in that respect. It was very unclear when it was first notified which provisions applied to non-scheduled sites and which applied to scheduled sites. And sometimes distinctions that were made were not made for a sound resource management reason, but perhaps just because there hadn't been a full appreciation of how the plan change needed to address both categories of site. That has now been improved significantly, but there are still some remaining issues with the way that those provisions address non-scheduled sites. The first point that I deal with is policy 6334 capital D. So I deal with that at paragraphs 42 to 43. And this is a policy that applies when it applies to applications for resource consents. It's sitting in the urban effects chapter, and it essentially governs how when urban development of deferred zone sites must be avoided, and consequently when it may be appropriate for urban development to proceed. So it's an important and directive policy. As it was in the 42A report, it was still unclear whether it was intended to apply to those scheduled sites. That has now been clarified. Excuse me. The submission by Mr. and Mrs. Talley and the evidence from Mr. Percy seek to change the provisions change policy 6334D so that development could only proceed if it's listed in the schedule and if it provides the infrastructure that the schedule requires. And that the council is not proposing to adopt that, or does not recommend that relief is taken up. And that is also my client's position, is that would not be appropriate to do that. So insofar as Mount Hope Holdings is concerned, then the version of policy 6334D that the council has recommended is appropriate. There is a change that is sought by Appleby 88, and so I'm going to address that separately because it really relates to quite a separate issue. But in terms of the first issue of making clear whether it applies to both deferred and non-deferred and how those are treated, Mount Hope is happy with where the council has landed on that. Then at paragraph 43, I'm also dealing with rule 16325, which applies to subdivision in any zone that's subject to deferred zone rules. And this is one that is probably unlikely to affect Mount Hope Holdings in practice because as it currently stands, any subdivision of that site was likely to be a non-complying activity, whereas Rule 16325 refers to subdivision where it is a controlled discretionary or restricted discretionary activity. So on its plain wording that rule would not apply. However, should there be any changes made to it, or if for any reason subdivision of Mount Hope site does come within one of those activity statuses, then the framing of that provision does become important to Mount Hope Holding. The way that council has now landed with this rule is that it makes clear that it is they propose to make it a generic rule that would apply whether a site is in the schedule or not. And that's a different approach to what had been sought in the legal submissions, but that approach would also be acceptable. So either would be fine, either to make it generic or to clarify that it only applies to scheduled sites as sought in the legal submissions. But in either way, it just needs to make clear how those non-scheduled sites are to be treated. There is one caveat to that, and that is that if rule 16325 is to become generic, then it's important that the change that my client has sought to rule 17421 is also made, because there is a connection between those two. So I'll come on to that change now, and that's dealt with at paragraph 44 of my submissions. So this is the rule for deferred land that is not listed in the schedule. And that rule states that for any deferred site not listed in the schedule, the plan provisions that applied to the original zone continue to apply regardless of 171422. The issue really is just with the reference to the original zone. That is proposed to be defined as the zone that applied to the land before the land was rezoned to a deferred zone. So that would be the rural zone. So the issue there being that the statement is made in the rule that the plan provisions the rural zone plan provisions continue to apply, when that's not actually how this plan works for deferred zone sites. It also has provisions that are specific to deferred zones, such as policy 6323. So if rule 171421 refers only to the original zone provisions, which mean that if the rural zone provisions, all of those provisions that are bespoke deferred zone provisions would not apply. So my client has just sought that there's a change to that wording, and this is in the all of this is in the schedule of wording that's attached to my legal submissions. So the change sought is just to refer to the plan provisions that apply to deferred zone sites rather than the original zone. The next wording change that's addressed in my submissions is 171420 principal reasons for rules. And again, this is within that same basket of provisions that relate to how deferred zones that are not in the schedule are treated. So the change that is sought there is really just in relation to the reference to deferred zone locations requiring further assessment and requiring a further plan change prior to servicing or development. The council has made clear that it's not their intention to block the consenting pathway for these sites, and yet that wording indicates that the only way that development can occur is through a plan change. That's not the intention, but it is what the words say. So the schedule to my submissions has recommended some different words that in my submission retain the council's intended outcome or intended policy intent, but don't inadvertently suggest that the only way to develop these sites is through a plan change. There's similarly a reference in 171420 principal reasons for rules to the need for there to be to these sites, to these non-scheduled sites being, quote, undeveloped land, and the need for a comprehensive planning in order to assess them. So again, it's that same issue that it's suggesting that these sites haven't been assessed and that there is a comprehensive assessment required when in fact these sites have been assessed, they have been zoned as deferred zones, and it's only the only distinction being that they're not in a schedule with a specific list of infrastructure and a specific trigger enabling a change in the rules that apply to them. So the relief sought in respect of that wording is also in the schedule. My submissions at paragraphs 50 to 57 are all on the same topic, but they are just responding to the planning evidence for the tallies. And in my submission, those changes are not. They are somewhat cutely presented as being clarifications when in fact they are a clear attempt to effectively downzone deferred zone sites in Mapua and Motueka. This policy intent of Plan Change 79 is not to do that, and changes to wording that are presented as clarifications but are essentially downzoning those deferred zone sites and treating them as rural zone sites should not be adopted on that basis. I'm going to move now to paragraph 62, which starts to address the relief sought by Appleby 88. The submission by Appleby 88 sought amendments to policy 6334 capital D to enable consideration of urban development where a site has road access that has been approved by NZTA. The purpose of this being that the Appleby 88 site is part of a sequence of properties that has an indicative road going through them. The delivery of that indicative road is highly uncertain because of, or at least the timing of delivery of it, because of the nature of the surrounding land, which is largely in rural production with no obvious moves to change it to a different form of land use. So because of the way in which that indicative road is going to rely on all of those properties changing to an urban, being subdivided and changing to an urban development in order for that indicative road to be delivered, Appleby 88 has sought to provide for the ability to develop its site with appropriate roading access that appropriately manages effects on the roading network, but without the need for that indicative road to be fully provided across all of those properties. So it simply sought to refer to the site otherwise having roading access approved by NZTA and or NZTA/Waka Kotahi. I couldn't see where that relief has been addressed in the 42A report, and that's what I've said at 64. In the adjournment just now, I've had a quick chat to Ms. Honey, and she advises that it was addressed, and the way in which it was addressed was in relation to the relief seeking live zoning of this site. So I've gone back and had a look, and I see where in relation to live zoning of the Appleby 88 site, the 42A report says that NZTA has said that this road access, that road access is only for rural uses. I haven't seen that indication. I haven't seen that letter. That's not my understanding, but I've only just been made aware of that. That is the council's position just now, because I hadn't understood that to be. I hadn't understood the 42A report to be responding to this point when it made that comment. So what I would like to be able to do is to get a copy of whatever the council has that addresses this issue of road access and be able to provide a brief further comment on that once I've had a chance to consider that letter. Regardless, the principle is still the same, whether there is actually a letter from NZTA saying what the access is approved for or not. The principle that there is an approved access is still something that in my submission is appropriate for this provision to cater for. This is the policy 6334D, as I said earlier, is a policy that is dealing with, it would be applied on applications for resource consent that are for urban development of a site. And it's framed in relation to it. When you look at B and C of it, it is framed in quite a general way. So necessary servicing and infrastructure to an appropriate standard has been delivered. It's not referring specifically to schedule infrastructure that is listed in the schedule. It's referring to infrastructure in a general way. The only place in which it is expressly referring to the schedule is in A, where it refers to intersections, connections and upgrades of roads as identified in Schedule 1714, capital A. So on the basis that there was only a link to the schedule in A, the only relief that was sought by Appleby 88 was in relation to roading. The remaining points were framed more generally as appropriate infrastructure, which would enable infrastructure to be provided that addressed effects and catered to the needs of the development, but not necessarily the development that was the infrastructure that was listed in the schedule. The definition, I'm down at paragraph 67, the definition of the definition of delivered is now proposed to cross-reference to the definition in Rule 1714.2.2, so that anywhere that the word delivered is used in this policy, it would essentially be referring to the infrastructure that is listed in Schedule 1714A, because that is how delivered is defined in Rule 1714.2.2. So that does create difficulties in that there is no provision for infrastructure that doesn't exactly meet the requirements to be provided, and therefore the issue with things like provision of an indicative road that hasn't been provided, that when that's not provided by surrounding properties, arises. So my client's position is that if there is, as long as servicing to an appropriate standard is provided, it shouldn't necessarily need to be the infrastructure that is listed in Schedule 1714A. That list of infrastructure is appropriate as a trigger provision for the deferred zoning provisions to change, but it's not necessarily the exact infrastructure that would need to be provided if development occurred through a resource consent process. So the mechanism to address that is the proposal that the word delivered is changed to provided in that policy. The issue around flexibility for transportation requirements, it was also sought through a separate submission point and to be achieved in a different way or in a complementary way through a reference to individual sites having designs that anticipate a roading network but which also have NZTA approved access and having that wording inserted into the schedule itself. So that's the other way that the transportation approach has been proposed to be achieved for Appleby 88. So that's the wording that's been inserted into the schedule in my schedule that was attached to my submissions. The same issue arises that council, I'm now advised that council position is that the actual access is not for urban use according to a letter that they have from NZTA. So for that, on that point again, I would just seek leave to get a copy of that, understand what it says, and then provide a brief response on that point. Moving on to paragraph 71, just check my timing. Oh, I'm about at time, so I'm nearly through everything. Do you have time for me to continue for another 5 minutes, or would you like me to?
I'm just going to check with Mr. Johnson. Mr. Johnson, did we have Mr. Hulsmeyer or Gordon Webb appearing?
No, they haven't responded to any emails, so it looks like they're not here.
Happy to indulge you a few more minutes, and I have a couple of questions.
Thank you very much.
Please proceed.
Thank you. So I'm at paragraph 71, which is in relation to Rule 17.14.2, Appleby 88 sought to allow 15 years in respect of transportation requirements rather than 10 years. This is essentially the sunset operation of these provisions, and that is again because of the nature of the surrounding land and the fact that the indicative road may not be able to be provided across all of the properties that are currently not contemplating urban development, and therefore Appleby 88 may lose the benefit of its deferred status through because of the nature of the surrounding land use rather than because it's not appropriate for urban development. So it had sought a 15-year, essentially I'll call it a lapse period. It's not truly a lapse period, but if we call it that, the rationale was around funding for infrastructure beyond 10 years of the long-term plan. But in this case, we have specific policy support for infrastructure being provided either by the council or by a developer. So the link to the 10-year long-term plan funding period doesn't appear to be particularly relevant, given that infrastructure may well be being funded by a developer. Paragraphs 73 to 75 really just express a minor technical matter, which is the intended start date for that lapse period. I have assumed, and the submission assumes, that the start date is the date that the provision is that the gosh, I'm not putting this very well. I'll start that again. With respect to the schedule, that the lapse date is when a site is included in the schedule and therefore able to be treated as a deferred zone scheduled site, and that the 10-year period would run from that date. But the heading of column I, if that's intended, the heading of column I is a bit uncertain because it refers to the number and operative date of the plan change that rezones site locations to a deferred zone. That could have well been some years ago. So that's not understood to be the intention. And we have submitted that should refer to the number and the operative date of the plan change that adds a site location to the schedule. The paragraph 76 and 77 refer to the meaning of delivered and oppose the changes recommended by Mr. Percy to reference delivered as being only in relation to infrastructure that physically exists. And I support the council's reasoning on that the flexibility the realities of development are that development is often funded as part of a subdivision being delivered. So to have the need for that to be physically in place before there can even be an application for consent that is supported by appropriate urban provisions is really putting quite a significant barrier in the place of urban development. I'll move past 78, which is responding to Mr. Percy. 79, the relief the matter addressed at 79 has now been addressed by the council, confirming that they agree that those references to water supply network and stormwater should come out of the schedule for RW5. They were added through the 42A report, but the council is now saying that they should come out, and that is supported. They're neither within scope nor appropriate. And the council was also agreed with my last point at paragraph 83 that chapter 6 should be added to the list of provisions that apply before services are provided. So those conclude my submissions and the relief sought by Appleby 88 and Mount Hope Holdings. And I'm happy to answer any questions.
So what I heard from Miss Honey this morning when she read through her statement, and I've just gone back to it as well. And I've been having a look at the principal reasons for the rules version of the 42A report and is notified. And the principal reasons is some deferred zone locations shown on the planning maps located in Motueka and Mapua are not included in Schedule 1714A because they require further assessment for zoning and servicing. No trigger provision is available for these sites, and a further plan change is necessary prior to servicing or development. And then I heard Ms. Honey say this morning that the resource consent and private plan change pathways remain available to these deferred locations. So what I take from that is there is no trigger, there is no moving from the underlying zoning to the urban zoning. That would only occur plan change or resource consent. Is that your understanding?
There is no trigger for those sites that are outside, that are not within the schedule, yes. That's my understanding.
So what would the new policy achieve that you're seeking?
The new policy that is under policy 6334D on my, is that the one you're referring to?
Yes.
Yeah. So this is dealing with the situation where a policy, where a resource consent is lodged for a deferred zone site that is not scheduled, so that it's open to an applicant to apply for resource consent with respect to one of those zones. There is a policy that specifically describes how resource consents are to be assessed when they are scheduled, and that is 6334D. But the policy approach for sites that are not scheduled when they're seeking a resource consent is unclear. So the position with respect to that policy was that if a policy is considered necessary, then this would be appropriate wording to fill that gap. Since filing these submissions, the council's produced its reply to evidence, which, although it doesn't address this because it wasn't provided as evidence, it does address a similar issue because a similar issue was raised by Mr. Percy about a policy gap for deferred but non-scheduled sites. And the council says in response to Mr. Percy's evidence that the policy 6334B is the one that is intended to address that scenario. So I find policy 6334B a little difficult to understand. So I didn't understand that that's what it was seeking to do. If you have that, if you have the 42A report version, it's on page 5. It's providing for the provision of services to be provided by any person or by the council, and it's making clear that it's for any part or all of the land. And then it has the reference to ensuring that concept servicing plans are required to be implemented under the urban zone through subsequent subdivision or development. But it doesn't really appear to be a policy saying urban development can be considered where it's been appropriately, where infrastructure has appropriately been provided. So that wasn't clear to me that that's what it's doing. So that was the reason for the recommended new policy. But things are moving as when a submission or evidence is made that a policy doesn't provide for a scenario, there are generally two routes that the policy could take, and sometimes the council takes a route that then makes the relief that has been sought sort of no longer relevant. So it's just been a bit of a moving feast with trying to provide something coherent when things are changing in that way.
So your change to 17.14.2.1.
Yes.
How would that work in terms of the no longer being a trigger through sites and schedules?
That's attempting to acknowledge that deferred zones in that, when I come back to my two scenarios of a resource consent process in advance of a trigger, or with where there is no trigger, and then provisions that address the trigger itself. So dealing in when we're in the camp of a resource consent application where there is no trigger, there are provisions that apply to deferred zone sites, and the ones that I've just been going through, 6334A to D, are examples of those provisions that apply to deferred zone sites. They are not provisions that applied to the original zone, because the original zone is simply the rural zone. They only apply because the site is deferred. So it's important that 17.421 recognises that the plan provisions are not simply those original zone sites. There are deferred zone provisions. Even if a site is not scheduled, there are still deferred zone provisions that apply to it. Policies.
It is confusing, isn't it? Do you think that rule would be slightly ambiguous? Is it a rule?
It's more like an advice note, isn't it? It's very it's unusual for a rule. It's attempting to implement the policy intent that there is not a trigger for non-scheduled deferred land. That is its intention, I think. But what it inadvertently does is tells the reader which plan provisions apply to deferred zone sites, and does so in a way that's not accurate.
Do you think it's virus?
Possibly not.
If in relation to the submission you made in relation to paragraph 76 about delivered,
yes,
that would also be, and it's planned delivery. Would that also follow where you get stage developments where during the process, and I've seen developments 6 or 7 stages, the infrastructure is delivered on a gradual basis?
Yes, exactly.
That's what I thought you meant.
Just going to slightly defer from protocol now. Ms. Honey, can you please run us through what is the intent in terms of this deferred sites in Mapua and Motueka through this plan change? I know you have covered it in the 42A and reply in this morning, but if you can just take us through it again, that would be helpful.
Yes, I will, and I agree it's confusing. It's because different plans or parts of the provisions, parts of the plan are trying to work together and support each other. So the intention is, which we tried to clear up in the hearing version, is that the existing policies, the operative policies that are there for deferred zones, continue to apply to all deferred zones within the schedule or not. These policies being 16334A and B are not as clear or directive as the new policy 16334D because they're older. I agree that 1714.2.1 does not acknowledge that rural one deferred residential is different to rural one, and that wording might need to be tweaked. But to keep a policy, a provision support pathway for non-scheduled sites different to policy support for scheduled sites, I prefer that we didn't mix up 334D, that we kept a 334D that applied, as it's worded, that applied to scheduled sites and the trigger. And if necessary, we had a different schedule 6344E that applied to non-scheduled sites and did not use the word delivered and did not refer to 1714.2.2. So it's really the approach is to try and keep the existing operative pathway open for deferred land that isn't scheduled, and to provide directive policy support for triggered land that is in the schedule. And if we can just keep that approach intact, I think it will help us, because quite a lot of the criticism from Mr. and Mrs. A&S Talley is that we confuse the two. And I buy that point. Let's keep it clear. Let's keep the pathways clear and separate. So rather than meddling with the hearing version wording of 16334D, I would prefer to have a 16334E with similar wording and reference to the appropriate rules in Chapter 17 that does not use the word delivered. I think it could be as simple as that, but the substantive issue around that is we are adding a new policy that supports deferred zones that are not scheduled, which may be appropriate considering we have affected that pathway and we've acknowledged it.
So what would happen for deferred sites that are not scheduled in terms of their ability to use urban zone provisions?
They have the existing operative policy support at the moment.
So what would be the process? So at the moment, in terms of the plan change that we're considering now, there is a trigger where infrastructure has been provided and the landowner can benefit from the urban zone provisions once the council has put on its website that infrastructure is delivered. So what would happen with Mapua and Motueka sites?
They would apply for resource consent and show that the infrastructure is provided in that consent, and they would have a policy pathway that supports their application.
Is that Byries? I'm going to ask again. Isn't the whole purpose of this plan change been to deal with issues of uncertainty about the existing plan provisions?
I think that's far I don't particularly have an issue with adding a 6334E that applies to non-scheduled sites, given that we acknowledge we have affected the non-scheduled site pathway, the Motueka Malpa pathway. So I don't have an issue if it buffs up the policy support.
Yeah, okay, thank you, Ms. Honey. Made your position clear. I'm just not clear myself that that is a Byries approach, and I would want that to be supported by legal advice. So I'll just turn back to Ms. Jett.
So there's no ability for the provisions that apply to non-scheduled sites to flip from one set to a different set. So there's no mechanism like there is for scheduled sites. All what I'm seeking here is to ensure that the policies that apply to a deferred zone now are not amended in a way that removes opportunities for a resource consent to be assessed on its merits. So it's not that resource consent would be applied for under the rural zone rules. The rural zone policies would apply to it, but also some policies that already cater to deferred zones that are not in the rural zone chapter would also apply to it. So it wouldn't benefit from any different rule framework. It would simply, we're just dealing with the framing of the policies that do apply to it to ensure that they aren't inappropriately changing in a way that, or framed in a way that suggests that deferred zone is actually just a rural zone, because that's not what this plan change is doing. And the concept of a pathway for deferred zone rural sites to obtain resource consent, as Ms. Honey explained, is something that the plan does provide, and I don't have an issue with the Byries of that approach, as long as it's clear which provisions apply to which. Yeah.
But you agree it couldn't flip the zoning?
It couldn't flip the zoning or flip the rules that apply, depending on.
So you'd be comfortable for your clients to apply for a resource consent on the underlying zoning?
Correct. Rural zone rules and the policies as we find them.
Yeah. And then the correct approach would be a subsequent plan change process.
Yeah.
Okay, thank you. Any other questions?
I mean, so I'm clear in my mind, which I'll just check with the council officers. That was always the intention, was it not? It's just that we've got a bit confused along the way with some of the wording.
It was never the intention to close down the development pathway to the deferred zones that are not in the new schedule. And for that reason, we did not, we retain the mapping, the deferred mapping. But post notification of the plan change, submitters picked up that the policy wording that we had provided in the notified provision was muddled. And we've tried to fix that. And if any more wording is required, it's to try and retain the two pathways, not in a muddled way.
And I'll just add to that, if I may, that certainly support what Ms. Honey has said, that that was never the intention. And I understand that there does need to be some amendments to 1714(2)(1), because I accept that that is, but it is artificially limiting it to just the consideration of the rural one, where in these non-scheduled sites it is more complicated than that. There is the deferred zone status to deferred zone to contend with, and therefore the policies that need to come into the mix. So I would support broadening out, or at least us working on how we can effectively change the wording of 1714(2)(1) so that it isn't just considered as a rural one zone, or the original, whatever the original zone was.
You can anticipate that as a question that will be coming for your reply report. And I have again taken up what Ms. Jepp said around the NZTA information. Is that advice that you have to hand that you can make available?
Yes, it is. We do have the NZTA letter.
Yeah.
Okay.
Yes, I can forward that through. Or who do I send it to?
Well, so that was actually a question that I had procedurally. A number of these documents, would you like those documents as part of, because I think there's two opportunities for a reply, one verbally today and one in writing in due course. Those documents, would you prefer them today if that's achievable, or
just as soon as possible? They will not form part of your final reply because we will give Ms. Jepp an opportunity to respond to that. And you will also be going off and doing some expert conferencing with Mr. Percy and potentially Mr. Taylor as well. Actually, with Mr. Taylor as well. So,
okay. Well, we'll have that the NZTA information while you're away on your site visits. We'll have that when you return.
Any final comments?
Just with respect to conferencing, as my clients don't have a planner, can I have an opportunity to comment on the outputs, or yeah, I know it's whatever makes it fair, but
I was anticipating you might ask that question. We'll have a think about that, and obviously if we were to do that, we'd need to extend that to other council.
The other alternative is Mr. Taylor has been involved for my clients more generally, but hasn't given evidence on this matter. So it may be that he could also represent their interests if you were comfortable with that, despite him not having filed evidence on their behalf. So that would be another option. I say, having not spoken to Mr. Taylor about it, but
what do you think, Mr. Taylor? Thank you. That would be very helpful. On that note, thank you for indulging us for a bit of extra time for questions, but that's been incredibly helpful. We are now adjourning for our lunch break and site visits, and we will be reconvening at 3 o'clock to hear from the tallies.
My clients, particularly by West Horticulture, have asked that if the panel are open to it, they would very much like you to review the boundary between the land and the land. They think it's indicative of the way that the land can be raised, because that's what's been contacted. So if you are agreeable to that, provide contact details for Mr. Patterson, and he will be able to usher you into site, leave you there, and you can vacate it. Thank you. And the second is in relation to conferencing. Is the panel anticipating that that will happen today, tomorrow?
It won't be today. So it would be very helpful if you could make Mr. Taylor's availability known to us.
He is available tomorrow. I understand if that's suitable.
We have yet to talk to Mr. Percy, and then to council officers in terms of their availability. But it's also likely that we're wanting to set questions for the planners, and whether or not we have those in time for tomorrow is also another. Yeah.
Consideration, so we have very much open to time to do that and as suitable.
Great, thank you very much. Okay, adjourned, back at 3 o'clock. Thank you.
Yes.
Yeah.